I'm Zurc, and this is Deviants, the show that interrogates the places where our systems punish, but rarely prevent. This episode is part one of a two-part series that discusses sexual offense investigations and decoy operations. But we won't have too many graphic details. And Danny has another content note. Danny?
I'm a practicing solicitor in England and Wales, but I'd just like to stress that I'm here as a co-presenter with Zurc of this podcast, not in a professional capacity. So what I'm saying is that although I may share legal information here and express an opinion about it, nothing that I say should be construed as legal advice. It's simply my own personal opinion as a presenter of the podcast. If you're looking for legal advice, then please approach a legal professional in whatever jurisdiction you are, and don't take any advice from me in this context. That's my back covered, Zurc. So where are we going with this?
Oh, thanks, Danny. You're in a chat, and the profile says he's 14 and cute, and you hesitate. And he keeps writing. Or rather, someone keeps writing. You don't know it, but on the other side is a trained adult, an officer, nudging, waiting, and documenting. In some states, this is a lawful sting. In others, the same police conduct could be the textbook definition of entrapment. The line we draw around government creating crime changes as you cross state borders in the United States and international borders from the UK to the US. And I think, Danny, even within the UK, between Ireland, Scotland, and England. Is that right?
Yeah, particularly the Republic of Ireland has completely different laws about which I know very little. In England and largely in Scotland and Northern Ireland as well, the law on this is pretty clear cut.
Okay, the first thing that we want to do here is define entrapment. What is it? What does that mean?
Entrapment is where somebody is enticed or talked into committing an offence. And in the UK, it is not what's called a substantive defence that will automatically get a case thrown out. The legal focus for a successful prosecution challenge is whether the conduct of a state agent, whether that's a police officer or the local authority, was so improper as to constitute an abuse of process or render the evidence inadmissible. So if somebody is enticed into committing an offence that they would have committed anyway, then entrapment is not a legal defence against it. Now, there's a very famous case that anyone studying law these days will know about because it made a substantial difference in the UK. And that was the case against the Crown versus Loosely. If I remember correctly, this was a guy called Grant Loosely, who was talked into supplying an undercover copper, or police officer, with heroin. He appealed against this, saying that he was entrapped by the officer, who was informed by what's called a gross in the UK, or by another criminal, who informed him that he was a drug dealer. And the officer went along. Well, he didn't. He actually phoned him on his mobile phone and said, can you sort me out with a couple of bags? Didn't mention heroin. And Grant Loosely said to him, yeah, sure, mate. Meet me in such and such place. And I'll sort you, man. I'll sort you. And so the couple goes along. Grant comes with his couple of bags. They do the deal. And the police officer says, you're nicked, mate. Now, before this case, the whole thing was a bit grey under UK law. There's a bit in the Police and Criminal Evidence Act, or PACE, from 1984, saying that a judge can exclude evidence obtained by entrapment if its admission would have an adverse effect on the fairness of the proceedings. And Mr. Loosely, who was subsequently convicted of drug dealing, took case all the way to what was then known as the House of Lords, confusingly, what's known now as the Supreme Court in the UK. And they actually stated that the conviction was sound because it was an offence that Mr. Loosely would have committed anyway. That he was a habitual drug dealer. He had not been enticed into dealing. And the fact that he was asked for a couple of bags, quote, and turned up with 2 little packs of heroin meant that she wasn't enticed into doing it. He was just doing what he would have done anyway.
Interesting. So you're saying whether or not they were predisposed. Did the person have a predisposition to committing the crime? Or did the police officer induce a normally law-abiding person to commit the crime?
Yeah, Mr. Loosely was clearly not a normally, I think he had previous convictions anyway, so he was not a normally law-abiding person. And so he wasn't coerced into it. But a lesser-known part of this case is that there was a second defendant who is anonymous because he was actually acquitted. And he was also a drug dealer, but was known for dealing in Class B drugs, cannabis, basically. And he was asked by the officer to supply heroin. And he said, no, man, I don't do the heavy stuff. No, a few hash cakes maybe, or whatever. And the officer said to him, "Oh, go on, give us some smack. Yeah, give us some smack. If you do, I've got a good source for cheap cigarettes." The dealer then said, "I'll see what I can do," and ended up supplying the heroin. And the law lords in the UK held that the judge was, as he did, entitled to stay the prosecution. So the guy wasn't acquitted of the offence. This anonymous person had obviously committed the offence. There's no doubts about that. But that the officer had used improper inducements, i.e. the contraband cigarettes, to persuade the defendant to commit a more serious crime than he would otherwise have committed. And so he was not proceeded against in law. This is Crown versus Loosely in 2001. And that was quite interesting because what the clarification about what inducement meant was that shops started becoming open to local authorities and police investigations about serving alcohol and tobacco to underage people. What it clarified was that if a local authority or the police took a young person who could quite possibly be underage and let them enter a shop and successfully buy tobacco or alcohol, then the shopkeeper or shop itself could be prosecuted for the offence. And this led to shops becoming far stricter. And given that this is when I was a teenager myself, I remember it. It became far harder for underage teenagers, to buy tobacco and alcohol because shops became paranoid about it and introduced a policy it was originally called Challenge 21 and was later tightened to be Challenge 25. And the staff were instructed that if anyone appeared to be under the age of 25, not under the age of 18, then they should demand proof of age or else be prosecuted. Because if a young person who's of questionable age walks into a shop and attempts to buy tobacco or alcohol or any other product they're not legally allowed to be supplied with, and the member of staff allows them to buy it, then they are open to the full force of the law because they're not being entrapped into committing an offence. They are simply committing an offence that they would,
Right.
in other circumstances, have committed.
Right. Well, okay, but for sexual offenses online, when we're talking about somebody's sexual behavior in private,
Yeah.
alone in their room, sitting at their computer, this question of whether or not you were predisposed to engage in this behavior. So that's the subjective test. The subjective test asks if you were predisposed, or the objective test, which asks whether the police tactics would induce a normally law-abiding person to commit the crime. I feel like that actually becomes kind of important. The federal government in the United States and most states in the United States use the subjective test. They ask, is this person predisposed to commit this crime? Are they a pedophile? Are they a child molester? Okay. But a significant minority use the objective test. They ask whether or not the police tactics would induce a normally law-abiding person to commit the crime. And that includes California, gigantic state, Michigan, and Utah. And it centers on police conduct rather than the defendant's history. We're talking about the tactics of the police versus whether or not a person was predisposed. Those are pretty different tests there. And decoy stings, decoy minor stings, where an adult officer pretends to be a teenager, are by and large widely authorized in the US. And I guess in federal law, right, courts have repeatedly held that the government doesn't need a real child for an enticement conviction. Interacting with an adult decoy can be enough. And here in Oregon, where I am, that's like written into law. There's an explicit, there doesn't need to be a real child. Interacting with a fake child is enough to break the law. And this isn't rare. I'm not talking about something that happens once in a blue moon, okay, in the US at least. I'm talking about the Internet Crimes Against Children, Department of Justice ICAT program, okay, for 2024, reported 203,000 investigations and over 12,000 arrests across the 50 states. Scale like that shapes lives, okay? It shapes people's lives and understanding of the world around them. It shapes court dockets. It shapes public narratives, okay? And what I want to ask is, what do these different legal lines do in real life? Who gets caught because of these shifting boundaries around what entrapment is? And why? Why is it that we are so willing to fund stings, but we don't have any funding for the primary prevention of sexual abuse that might keep people from crossing that line at all?
There is a difference in the US that entrapment by a law enforcement officer, if it can be proved, is an absolute defense and can result in acquittal.
That can't happen in the UK?
It can't. No, it's not an absolute defense. It can result in a
That's
stay of
interesting.
prosecution so that the case isn't acquitted but it's not proceeded with. Or it can result in a lesser sentence. But no, it's not an absolute defense.
I guess it's just when you're talking about predispositions, okay, and sexual behavior, you're not talking about drugs. You're talking about somebody's private, intimate sexual behavior that they may not have talked to anybody else about in their entire life. That they have been with drugs. If you're engaging in even the most innocuous drug, alcohol use.
Well, the most
Okay, well, it's not innocuous, actually. It can be really dangerous. But even with alcohol, which is legal everywhere as a drug, okay, if I start drinking when I'm 13 years old, okay, and there's no way for me to get help, and I'm 35 and I have been drinking alcohol since I was 13, 14 years old every day, and then a police, can you imagine a police officer come up to me and say, "Hey, do you want to buy a fifth?" Okay. Obviously, yeah. Like, I don't mean to be like, there's no way to get help. I'm just in this fake scenario, fake world that I'm describing to you. We don't have any alcohol abuse prevention programs. There's no one even recognizes that alcohol abuse is a problem. You got a guy that's been drinking since he was 14 years old. A cop comes up and says, "Hey, I got a fit. Do you want to buy it?" And doesn't say that they're a cop. And just obviously, yeah. But so like, it's just that scenario is so, if we try to map alcohol or drugs onto the sex offense universe of things, it's so absurd the way that we're handling the sex offense side of things compared to the way that we're handling the substance use side of things. It's almost like we've taken all the laws from substance use and applied them to the sex offense universe of things. But we haven't taken any of the prevention, any of the learning that we've done, understanding how people's brains work, being trauma informed, trying to think through creative ways to get people to get help. And so we just didn't take any of that. We just took the law. We just took the prosecution. We just took the punishment. And I think it's hurting a lot of people in the US. I think it's really like families. And when you look at it, it's really scary. And your entrapment odds, what counts as government creating crime, is actually changing from jurisdiction to jurisdiction. And a chat log can mean two totally different trials depending on where you stand. Okay. And you look at Utah. In Utah, we see this objective lens. Okay. What they're going to say is entrapment occurs depending on the police conduct. Okay. And very recently, there have been cases in online decoy stings that get upheld and affirmed. The conviction gets affirmed. There's no entrapment as a matter of law because when we apply this lens, the tactic, what was inducing someone who wouldn't normally be law abiding. But when you're talking about sexual behavior, like we're talking about something where that person's sexual development began when they were 13 and they're getting caught when they're like 35, 45 years old. They've had no intervention their entire life. They've had no way to get help. They've been scared. They've been alone. They've been suffering. And they've desperately wanted help for a long time. And then we're saying that person isn't normally law abiding. And so therefore this isn't entrapment. And it's just, they don't have any way to get help. How do you know that? How do you know how do you know they wouldn't have tried to get help if there was a way?
Well,
What do you
some people
think?
would say, I wouldn't personally, but some would say they get help once they've been caught and once they've been convicted. And how can we have detected what they were doing before that?
That's a good point, but I want to remind you of the numbers that I read earlier. Okay. 203,000 investigations, over 12,000 arrests. Danny, that's billions of dollars. That's teachers' salaries. That's their raise. That's the raise for our school teachers, our elementary school, our primary school teachers, our high school teachers, our middle school teachers. That's their raise. Out the window. Gone. That's what we getting up for. That's that's a raise for police officers, better equipment, safer practices, trauma-informed training. That's gone. We just arrested 12,000 people. That's the sentencing in the United States for this crime is not a joke. It is not funny. It's not cute. It annihilates people's life. It puts them in prison for a very long time. I'm talking decade plus.
The UK is different in two ways here. First of all, the police sting or law enforcement sting is far less common.
Yeah.
It's really only used
No,
Yeah. Oh,
really?
yeah. Most of the convictions for what's commonly known as online grooming in the UK are through like ordinary citizens, and the
That's
bar for
fascinating.
professional behaviour for a member of the public is far lower than it is for law enforcement officers. Yeah.
That's a really good point. So who's in the crosshairs, right? Like who's getting caught? Okay. And in the US, this is a really interesting question because the US is very concerned about, or I'm sorry, I shouldn't say the US. At least in my state in Oregon, I admire Oregon because it does do, it's not perfect, but it does try to suss out where there's like overrepresentation of certain groups and
Yeah.
classes of people. And when you look at who's in the crosshairs of these sting operations, okay, some classes stand out. Okay, LGBTQ people, okay, stand out as a class of people that are crucial to understand when you're looking at the entrapment lines and how they're sort of policed. And academic reviews and major market reporting show that these operations continue in parts of the country and carry severe downstream consequences that negatively affect gay and bisexual men
Yeah.
in particular. Okay, disproportionate. Okay. And civil rights cases and advocacy accounts detail these sort of like mass sweeps with sustained convictions, but lasting harm. I'm
Yeah.
talking outing people that are parents, that are fathers. Okay. They're outing like dads. Okay.
Mhm.
With young children. We're talking job loss. And in some jurisdictions, talking even like sex offense registration tied to lewd conduct. And once you register as a sex offender, Danny, you can't even be a
Yeah.
parent to your child anymore. The
Yeah.
state will get involved to literally forcibly separate the man and steal, like literally rob their right to parent their child. And the pattern is the point, okay? Civil rights cases and advocacy accounts detail these sort of like mass sweeps with few sustained convictions. So they're not convicting very many people, but they're sweeping up a big number of them, pretending to be the police, pretending to be these children online. And they're contacting CPS. Okay. They're contacting the Department of Human Services and they're getting the child welfare person out to the home. Okay. And the moment that happens, we're talking dads, like parents with young children getting outed, okay, losing their job, okay. And in some cases, when there is a conviction sustained, they could even go on the registry. And once they go on the registry, the state can forcibly separate the parent from their children and deny them the right to be a part of their
Mhm.
child's life. And that's just, when we're talking overrepresentation among LGBTQ people, we're talking about a lot of gay parents there,
Yeah.
man. Okay. That's like gay dads. That's like dads who've spent their entire life and maybe they have a sexual behavior problem that's been going on since they were a child and they haven't been able to get help and they're scared and they're alone and they have nowhere to go. Okay. And somebody shows up on the internet. Okay. And says, oh, hey, I got some interesting pictures, or I don't know how it works. Oh, hey, I got some interesting pictures, here, let me just send these to you or something like that. And the dad says, oh, in a moment of weakness, maybe they've had a beer. And they say, yes, boom, child welfare, police, FBI, arrest,
Mhm.
registry. That child doesn't have two parents. Now they have one parent and they have another parent that's humiliated and they have to go to school. Okay. And all their friends know. That's not how we want to operate as a society.
No.
Okay.
No.
I think. The other group we're talking about are these people with disabilities. That's the other one that personally, I care about a lot as a person with a disability. Okay. And these sting tactics exploit people with intellectual or developmental disabilities. Okay. And there's been groups that have called on the DOJ, like the ARC, okay, for oversight. And it's not a theoretical concern. Okay. suggestibility, desire to please, and communication differences for somebody with a disability. For someone like myself, like I have those, like I'm reading this, I'm reading this script and I'm thinking of myself like, no, like, wait a second. I have some issues with, I'd like desire to please and suggestibility and communication differences. Like, I mean, I'm not engaging in any illegal behavior, but I can see myself in this. And I could imagine a world, again, people don't talk about their private sexual behavior, especially people with disabilities. So they started developing whatever behavior the law is claiming they were predisposed to engage in or that they would normally engage in. They had started that when they were really young and they couldn't get help. Okay. And they have a disability. I mean, it's just, that's not, and again, that's the teacher's raise at your school. That's your new sport equipment for your school. That's your safety training and your trauma aware and trauma informed practices in your police department out the window because you're spending all the money to arrest these people because they could never get help.
I think, yeah, in the UK, although, as I said, entrapment isn't an absolute defence against conviction, there is, when it comes to the police and state agents, as in the Crown versus Loosely case, a protection of the integrity of the criminal justice system from the misuse of state power. And that is a legal basis for a stay of prosecution. Yeah. And the key test.
Do you know if are there cases of sexual offenses where there's like cops pretending to be kids in the UK?
Not in the UK.
There it is, yo. That doesn't happen.
Yeah.
That's interesting. So, all our listeners, I want to just, let's repeat that. So I just want to clarify. In the UK, what I'm asking is, does it happen that a police officer gets onto his computer, pretends to be a 13-year-old girl, and then talks to adult men?
No, because one of the key tests to entrapment is whether the officer went beyond of offering an unexceptional opportunity. And so an unexceptional opportunity would be a kid in a chat room. Yeah.
That's so interesting.
But if they instead lured, incited, or pressurized the defendant. So someone comes along and says, hey, the copper comes along and says, hey, I like kids your age, or I'm your age, would you like to meet up? Then the likelihood is that the case would be stayed. The prosecution would be stayed. It wouldn't be acquitted, but there would be no.
Oh, that's so interesting. So in the UK, the police will pretend to be kids to catch.
I don't even know if that's happened. The legislation states that the courts must prevent the state from prosecuting state-created crime. So if an officer posed online and tried to groom a child and, posed as a child and tried to groom an adult effectively and met up, that would be a state-created crime.
That concludes part 1 of our 2-part series discussing sexual offense investigations and decoy operations in the US and the UK. We'll be back next week to talk about Manufacturing Criminals, a book by Bonnie Burkhart and the devilishly handsome Stephen Coker that dives into more detail into this complex and nuanced problem. This is Danny and Zurc, and we're Deviants, and we'll see you then. Take care.